Hello everyone. Thank you everyone for making it today. Thank you also to anyone who is joining us online. There's a camera, so thank you people joining us online. As I'm sure you know, the talk today is largely, almost exclusively going to be about the recent Supreme Court decision in Deliveroo. Now, I'm in a situation where I think the first time anyone's ever said this, we do have a panel that really doesn't need an introduction. The issue with that is that I'm kind of out of the job if I don't do introductions, so I'm going to do them anyway. So I'll introduce people in speaking order, but at the end of the desk here we have Professor Anne Davies. Anne Davies is a Professor of Law and Public Policy at the Faculty of Law at Oxford. And her latest book, Valuing Employment Rights, a study of remedies in employment law, with Hart Publishing, will be available in all good bookshops in May. I will be getting myself a copy of that as and when it comes out. Next, we have Lord John Hendy KC. And so John is a KC at the Bar of England and Wales, and he spent most of his practice acting for trade unions and workers, both in the UK and internationally. You've probably seen his name on a number of European Court of Human Rights judgments. He's an honorary professor at the Faculty of Law here at UCL, and he's also a member of the House of Lords and president of the International Centre for Trade Union Rights, chair of the Institute of Employment Rights, and the vice president of the Campaign for Trade Union Freedom. To my left here, Professor Tony Kerr, and Tony is senior counsel at the Bar of England and Ireland. Sorry.
And Northern Ireland.
I think I just caused an international incident within the first 5 minutes, but we'll move on. He's senior counsel at the Bar of Ireland, adjunct professor at University College Dublin, Sutherland School of Law, and is the Ireland representative on the European Commission Centre of Expertise in the field of labour law, employment and labour market policies. And Professor Lizzie Barmes. To my right, Lizzie's been a professor of labour law at Queen Mary University of London since 2007. Her main current research concerns the history of the Equality Act 2010 and the impact of its positive action provisions, the role of NDAs and silencing, and more generally in the operation of labour law and equality law, and the dilemmas raised by current calls for socioeconomic discrimination to be prohibited. Now, as I say, they don't really need an introduction, but I did it anyway. So I think to kick us off this evening, Anne is going to start with a short introduction of the Deliveroo judgment, sort of the timeline of the case as it started in the CAC, went all the way up to the Supreme Court. Then John and Tony will be talking through the judgment itself, and then finally Lizzie is going to give us some analysis on sort of where we go next. So Anne, if I can hand over to you.
Yeah, thank you very much. Possibly Deliveroo needs no introduction either, but just in case you haven't been following it in intense detail, I will give you a quick overview, and then I'll set out some themes that hopefully my colleagues on the panel will pick up on. So this story begins really with the decision of the Central Arbitration Committee, the CAC, in November 2017. So this was an application by IWGB on behalf of Deliveroo riders in Camden and Kentish Town. And this was resisted by Deliveroo on the basis that none of those riders were workers under Section 296 of the Trade Union and Labour Relations Consolidation Act 1992, which incidentally has slightly different wording to the definition that most people are used to when they think about LINB workers, but that doesn't have any material consequences in the case. So the contract under which the riders worked included some familiar terms: no guarantee of work, no obligation to work, they were free to work for competitors, and a substitution clause. And the substitution clause was found throughout to provide an unfettered right, really, to send a substitute to do the work. So the CAC found that, as a fact, that most riders do not use a substitute, that's a quote, but a few riders do, that's also a quote. The rider has to take responsibility for the substitute, give them their phone and password. And that suggests that use of this is going to be fairly unusual, I would have thought. But CAC found as a fact that some riders use substitutes. So at the time, The leading authority on the domestic worker definition was probably AutoCleanse, and so the CAC applied AutoCleanse looking for the true agreement between the parties. So Uber is not around at this point for them to rely on. And the CAC says this: the central and insuperable difficulty for the union is that we find that the substitution right to be genuine. And we have also heard evidence that we accepted of it being operated in practice. In light of our central finding on substitution, it cannot be said that the riders undertake to do personally any work or services for another party. It is fatal to the union's claim. In a very brief paragraph, they mention that Article 11 of the European Convention on Human Rights might have something to do with this. But because the worker status issue, as far as they are concerned, is so crystal clear, they dismiss that in a sentence. Now, the way of challenging a CAC decision is by way of judicial review. So judicial review, as you will know, has two stages, and a permission was granted only on the basis that the CAC had erred in law in not considering fully the implications of Article 11 for the interpretation of worker under Section 296. So the case then goes to the administrative court, where the judge holds that an employment relationship is necessary for Article 11 to be applicable, and the riders don't have an employment relationship because they don't have an obligation of personal service. The case then goes to the Court of Appeal, which upholds the decision in the administrative court. We get a little bit more elaboration in the Court of Appeal of what's going on. Again, this idea of the employment relationship being crucial for the application of Article 11, and this must be answered using the ideas contained in the ILO employment relationship recommendation. This is Lord Justice Underhill in paragraph 77. Again, he focuses on the virtually unlimited right of substitution. That is on any view, he says, a material factor in the decision whether they're in an employment relationship with Deliveroo. And he goes on to say, in my view, the CAC was entitled to regard it as decisive. He also notes in his decision that the Uber case has been decided by the Supreme Court at that point. But he notes that the CAC's decision on domestic law is not at issue, and the case cannot be challenged. And he doesn't consider whether that also it has any impact on the interpretation of worker for the purposes of Article 11. So then we get to the Supreme Court, which is what I think we're going to be most looking about today. And again, we get this focus on the idea of an employment relationship being necessary to trigger Article 11 protection. They make reference to a case which is referred to in shorthand as the Good Shepherd case, in the European Court of Human Rights, which invokes the ILO employment status recommendation. And again, the substitution is fatal. So paragraph 69, the lower courts and the CAC have correctly focused on the power to appoint a substitute. Such a broad power of substitution is on its face totally inconsistent with the existence of an obligation to provide personal service, which is essential to the existence of an employment relationship within Article 11. And they're persuaded that the CAC had appropriately had regard to whether the substitution clause reflected the reality of the situation as well as the contractual arrangements. There's then quite a long obiter section of the judgment looking at if you do manage to get yourself classified as a group of Article 11 workers, what rights you have in terms of collective bargaining under Article 11. So I suppose asking and answering the question, does Article 11 require a government to legislate to require a reluctant employer to engage in collective bargaining, which they refer to, they look at Schedule A1 and they refer to that as compulsory collective bargaining. I'll come back to that. And they hold that DeMere did not lay down a requirement for compulsory collective bargaining. So that's where we are in terms of an overview of the cases. Let me throw out some themes for discussion. I think there are lots of potential themes, and maybe some others will come out as well, but I'll try and give us a little bit of a steer. So the first question, how do we assess the significance of this case? I sort of want to say, obviously, it's hugely important for the people involved, but maybe we shouldn't read too much into it. Every case turns on its own facts, particularly the factual findings of the lower court, or in this case, the CAC. I think we should resist the temptation to be overly alarmed in the same way that we should resist the temptation to assume that Uber has solved all of our problems. It's the UK Supreme Court's view of the Article 11 definition of a worker, where, of course, the European Court of Human Rights is the ultimate authority. And that's a decision on a particular set of facts and nothing more. So maybe we shouldn't be talking about it, but that would rather spoil the purpose of the evening. So let's talk about it anyway. And obviously, we'll see if colleagues agree with that assessment of its importance. So one theme that I'm sure we'll spend some time on is what would have happened if the case had started after Uber, and if the CAC had been applying the domestic definition of worker based on the Uber judgment. I like to hope that the outcome might have been different. Uber emphasises very heavily the need to focus on the statutory purpose and whether the individuals are in need of protection. It is noticeable, though, that the summary of Uber and Deliveroo downplays that purposive element of the case a little bit. Uber also emphasises the importance of considering the relationship in the round, not just one factor. So perhaps the substitution clause might not have been quite so determinative. And of course, in Deliveroo, it was seen as a reinforcing factor that the riders could choose when to work, when to log off. And of course, that was not conclusive in Uber by any stretch of the imagination. So for me, anyway, it kind of reinforces the point, which hardly needs reinforcing, that any approach which gives too much weight to a single factor is problematic because of the ease with which single factors can be manipulated. And it's important to look at the relationship in the round. I think later we'll hear from Tony about the Karshan case in the Supreme Court of Ireland, which makes that same point in an important decision, rejecting mutuality of obligation as a sort of single decisive factor. Third thing that I wanted to pick out is whether the Supreme Court is correct in its interpretation and application of worker for Article 11 purposes. I think it's obviously right to look at the ILO recommendation because that does reflect what the European Court of Human Rights itself has done. But it's quite a problematic source because it's directed at states. It's not there to lay down a test. And it represents a compromise when a convention couldn't be agreed, if I understand the history correctly. And to the extent that the recommendation does offer guidance, I think it's a multi-factor approach. It's not suggesting that any single factor should be determinative. So we're back to our issue about the substitution clause and why that is so regarded as so conclusive. A fourth theme, which we may or may not get onto, is the obiter part of the judgment, this idea that Article 11 doesn't protect the right to compulsory collective bargaining, so doesn't protect this the access to the recognition procedure. So the idea that Parliament can choose to provide a recognition procedure but isn't required under Article 11 to do so. And I hope we can have a bit of a discussion about whether or not that bit of the decision is correct. I think I may make myself unpopular by saying that on the current state of the case law in the European Court of Human Rights, I think it perhaps is, though I think there is scope to challenge discriminatory exclusions from access to that kind of procedure. But I would make a couple of other points about it. Compulsory collective bargaining, I think, is really problematic terminology to describe Schedule A1. Compulsion, actual compulsion, infringes ILO norms. The recognition procedure compels a process, participation in process. It doesn't compel bargaining, I don't think. And I think making it sound like it's a really onerous thing is dangerous because it has the potential to lead to really restrictive interpretations and applications. So I think that's a bit of a worry. The Supreme Court takes some comfort from the fact that the riders can still form and join a trade union and engage in voluntary collective bargaining without access to the recognition procedure. So it's not that they don't have any Article 11 rights at all. But this ignores a point that Alan Bogg makes powerfully in a note on this case, which is that the whole statutory edifice around collective bargaining applies to workers. So all the other elements of support that are in place, like the right not to be discriminated against because of your trade union membership or activities, applies to workers. So if you're not a worker, you don't get any of those other elements of support. It's not just access to the recognition procedure that's at stake. So it's less realistic, I think, than the Supreme Court suggests to say that they've got the option of voluntary collective bargaining as an alternative. And finally, my notes say what's going on with Article 11, by which I mean, where do we go from here, I suppose? One interesting question to my mind is whether we need to pay more attention to the facts of Strasbourg cases, or whether it's legitimate in the human rights context to treat cases as standing for broader propositions, particularly when they invoke the ILO and other materials. And I think part of the issue around DeMere might be a discomfort about extending it too broadly, given that it was a case with quite extreme facts. And I think that explains some of the nervousness around making broader use of it, even though it does contain some really important statements about what Article 11 means, what it includes, which could be applied widely in other different factual contexts. Another set of issues that I hope we can think about here is the role of what I would call judicial self-restraint. So the Strasbourg court uses margin of appreciation. The domestic courts talk about things like discretion for Parliament or striking a delicate balance between competing interests. And I think it's interesting to explore the extent to which these are legitimate considerations. If they're not legitimate, what can be done about it? And finally, where does all of this leave strategic litigation invoking Article 11? Where do we go from here in terms of trying to develop the case law? So those are my themes and questions. I'm going to let everyone else answer them now.
Right. So John, I will get your presentation up. Hopefully everyone can see that.
Okay. Oh, right. I thought you were going to give me a starting signal. Thanks very much. Well, I must say it's a real privilege to be on such a distinguished panel. A real honour to be invited to speak amongst such eminent labour lawyers. I appeared for the appellant union, the IWGB, in the Deliveroo case, ably assisted by Catherine Newton KC and Madeline Stanley. We represented the union at all stages of the litigation, which began, in fact, as far back as 2016. At every stage of the proceedings, we lost, and having mostly represented trade unions and workers during my years at the bar, I have to say that was not a novelty. It was, however, a bitter disappointment for the union, and much more so for the riders, as Anne has mentioned. The result was a surprise, I think, to most labour law practitioners and academics, but the surprise and disappointment is all the greater because of the poverty of the Supreme Court judgment, which, when you compare it to the case that Tony's going to talk about, the Karshan and Domino's Pizza case, it looks so poor, the quality of the judgment. I accept, of course, that the most obvious explanation for losing is the inadequacy of the principal advocate in presenting the case. However, I comfort myself that whilst brilliant advocacy helps and bad advocacy hinders, cases are rarely decided by the quality of the submissions made. Deeper reasons must be sought. Anne's outlined the facts, so I don't need to. The originating application to the CAC was as long ago as the 28th of November 2016. Well, one additional fact I would add to the catalogue that Anne has mentioned is that Deliveroo refuses to negotiate with the IWGB or any union about its riders' pay, terms and conditions. It sets these on a take it or leave it basis. Pay at the time was £3.75 per delivery. And you can work out roughly what a rider would be likely to get during the hours that restaurants were opened in the evenings, maybe 6 hours from 6 o'clock until midnight, considering that they have to wait, go to the restaurant, wait for the order to be prepared, pick it up, cycle to somebody's home, drop it off, and then report back. Can we have slide 2, please, Hitesh? So, as Anne mentions, the issue in this case was section 296 of the Trade Union Labour Relations Consolidation Act of 1992, because the CAC refused to accept our application on the basis that the riders were not workers within the meaning of 296, and they were not workers because the contract didn't stipulate that they provided personal service because of the existence of the substitution clause. And you see the requirement for personal service in 2961B undertakes a contract whereby he undertakes to do or perform personally any work or services. And what had happened here was that Deliveroo had inserted, without negotiation or consultation, a provision in the umbrella contract between it and each rider, which permitted the latter to use a substitute. The inclusion and the amendment of that clause could only be resisted by the rider simply leaving work, giving up the job. The CAC found that the right of substitution was used, quote, very rarely, if that, unquote, and that, quote, whilst most riders didn't use a substitute, a few did. So even the few who did use substitutes provided personal service most of the time. And for the vast majority of riders who gave personal service on every job, the right of substitution was a practical irrelevance. But, of course, the effect of the inclusion of the irrelevant clause in their contracts was that, unknown to the riders, they were debarred from being workers, which, of course, as Anne has mentioned, is relevant to their right to form a trade union, to their right not to be discriminated against as a trade union member, and various other rights. And more particularly in this case, it debarred the union from admission to the statutory recognition procedure. Now, as Anne has mentioned, we tried to judicially review that. We were refused on the grounds that 296 had been wrongly construed by the CAC. So but we were allowed permission to argue that the construction of violated Article 11 of the European Convention. So Hitesh, if we could have slide 3, just to remind those who are not familiar with Article 11, it's in 2 parts. And the first part is, after the right to freedom of peaceful assembly, is the right of freedom of association with others, including the right to form and join trade unions for the protection of one's interests. Now, that phrase, for the protection of one's interest has been construed by the European Court of Human Rights as containing a number of inherent rights within it. And in particular, as Anne mentioned, the case of Demir and Beykara and Turkey, if we could have slide 4, held that in the light of ILO and other international law, together with the practice of European states, the right to bargain collectively with the employer has in principle become one of the essential elements of the right to form and join trade unions for the protection of one's interests set forth in Article 11 of the Convention. So that was the basis on which we said, well, this is a wrong construction because we've got a right to bargain collectively under Article 11. And the relevance of this right to Schedule A1 has been recognised in 3 Court of Appeal cases. If we could have slide 5, I'll quote from Vining and the London Borough of Wandsworth, where Sir Terence Etherton held that the rights in question, and that was a right of collective consultation, not even collective bargaining. The rights in question fall within the scope of Article 11, is under a positive obligation to secure the effective enjoyment of these rights. That doesn't mean that it's under an obligation to ensure that they're available to all employees in all circumstances, but it does mean that where a legislative scheme is in place, it must strike a fair balance between competing interests, and any provision of that scheme which restricts its availability to particular classes of workers requires to be justified, albeit that the state is recognised to have a wide margin of appreciation. So it's a very important encapsulation of our argument. Contrary to what the Supreme Court say, we never argued that the state was under an obligation to erect a right of compulsory collective bargaining. Our argument was absolutely not that. It was, if there is such a mechanism, then our exclusion from it must be justified under Article 11.2, necessary in a democratic society for the protection of interests of others, blah, blah, blah. So the High Court, the Court of Appeal, and now the Supreme Court dismissed our claim for JR, but although the reasoning of each differed, the essential ground was the same as the CAC. In other words, personal service was an essential element of entitlement to trade union rights under Article 11, and the riders didn't provide personal service because of their right of substitution. Let me turn now to the Supreme Court's rationale. We can't look at we can't consider this evening the many flaws in the judgment, not the least of which was, as you've already gathered, my feeling that that our submissions were misrepresented in a number of crucial respects. I want to focus on one point alone. That is the failure of the Supreme Court to adopt a teleological approach, a purposive approach. First of all, we have to outline how the Supreme Court reached its conclusion. As Anne has touched on, it concluded that the riders were excluded from entitlement to Article 11 trade union rights because they weren't workers for the purposes of Article 11. And they reached that on the basis of the reference to the Good Shepherd case of 2014, where the European Court of Human Rights had considered whether priests in Romania could rely on Article 11 to overturn domestic law which prohibited them from forming a trade union. The court was guided by ILO Recommendation 198 in the determination of their eligibility for Article 11 rights. What the court did was to weigh the factors in favour of them having an employment relationship with those which pointed the other way. But in Deliveroo, the Supreme Court held that the application of Recommendation 198 led to the conclusion that in order to qualify for the right to form and join a trade union for the protection of one's interests, the workers must be in an employment relationship, a concept which the Supreme Court never defined. It further held that the requirement of personal service was an essential feature of an employment relationship under Article 11, though it never ever explained why that should be. I'm going to ignore this evening, just as the Supreme Court did in its judgment, the judgment of the Supreme Court 4 years ago in Pimlico, Plumbers and Smith, which applied section 2961B and held that the existence of a substitution clause in a worker's contract does not necessarily preclude a worker from being a Limb B worker if the dominant feature, those are the words, the dominant feature of the contract is personal service. So I will also ignore our lengthy submissions that personal service was a dominant feature of the riders' contracts in this case, both because of the extent of their responsibility for any substitute they did engage and because of the contractual fetters on engaging a substitute. Instead, I'm going to turn next to recommendation 198. So Hitesh, if we could have slide 6. This is the preamble of the ILO recommendation 198. And I just invite you to look at the italicized words. Well, I begin with the first paragraph. There is protection offered by national laws and regulations, collective agreements, which are linked to the existence of an employment relationship between an employer and employee. Considering that employment or labour law seeks, amongst other things, to address what can be an unequal bargaining position between the parties, considering the protection of workers is at the heart of the mandate of the ILO, and so on, noting that situations exist where contractual arrangements can have the effect of depriving workers of the protection they are due. Quite clear that recommendation 198 is about protecting workers. If we could have slide 7, we can see paragraph 9, which defines the purpose of the recommendation. The purpose of the national policy of protections for workers in an employment relationship, the determination of the existence of such a relationship should be guided primarily by the facts relating to the performance of work and the remuneration of the worker, notwithstanding how the relationship is characterized in any contrary arrangement, contractual or otherwise. So they're saying, look at the facts of how the relationship works. Don't look at the contract. Well, look at the contract, but the most important thing is the facts. And if we can have the next slide, is paragraph 11. For the purpose of facilitating the determination of the existence of an employment relationship, members states of the ILO, 155 nations on earth have ratified, are members of the ILO. Members should, within the framework of the national policy referred to in this recommendation, consider the possibility of the following: A, allowing a broad range of means for determining the existence of an employment relationship; B, providing for a legal presumption that an employment relationship exists where one or more relevant indicators is present, and then social dialogue. And Hitesh, if we can have slide 9, which is paragraph 13. I'm not going to read that, but you see the range of factors or indicia which the recommendation entails, of which only one is personal service. And they are referred to as indicators, which might include some of those set out. Now, we haven't got time to discuss the series of factors taken from recommendation 198, which the Supreme Court dealt with, which it alleged provided strong support for the conclusion the riders were not in an employment relationship and were fundamentally inconsistent with any notion of an employment relationship. I think the Supreme Court judgment was deeply flawed in that respect, but we have to leave that this evening. But having held that an employment relationship was a condition for entitlement to Article 11 trade union rights, the Supreme Court in paragraph 69, to which Anne referred, asserted that an obligation to provide personal service, quotes, is essential to the existence of an employment relationship within Article 11. But there is simply no mandate for that bold assertion, either in recommendation 198 or in the Good Shepherd or in any other of the cases which in the European Court of Human Rights. On the contrary, as we've seen, recommendation 198 requires that a broad range of factors be taken into account, none of which are suggested to be determinative on their own, and it recommended, as we saw, the presumption of an employment relationship if even one factor is present, and there were a number there. So ignoring Pimlico, which the Supreme Court did, the court concluded that the right of substitution in the writer's contracts was totally inconsistent with personal service. But if if the right of substitution was not totally inconsistent in domestic law, how could it conceivably be totally inconsistent under the protective scope of Article 11? So I come next to deal with a purposive approach to the entitlement to Article 11 trade union rights. It was our submission that Article 11, and hence 296 as conditioned by Article 11, must be considered purposefully. The same argument was mounted in relation to recommendation 198 and the other ILO instruments and jurisprudence. The purpose of the European Convention on Human Rights is plainly protected, as is Article 11. The phrase "for the protection of his interests" in Article 11 clearly warrants a purposive approach to the rights identified by the European Court of Human Rights as inherent in joining or forming a trade union. And the European Court held in an earlier case, which I appeared for the unions in, Wilson and Palmer in the United Kingdom, they said this: the words "for the protection of his interests" in Article 11, paragraph 1, are not redundant, and the Convention safeguards freedom to protect the occupational interests of trade union members by trade union action. Damir and Beikara repeated that paragraph word for word. We can conclude from that 3 points. First, the rights under Article 11, which are to be protected, are occupational in nature. In other words, they must be interests which relate to the work carried on by the relevant group or individual. Secondly, the interests are those of the trade union members or intending trade union members in question. And thirdly, they are interests which are capable, at least in theory, of being protected by trade union action, whether successfully or permitted or not. Trade union action to advance the occupational interests of members, of course, can take a number of forms, of which the most characteristic anywhere in the world is the conduct of collective bargaining. So coming back to the Good Shepherd that Anne talked about, Good Shepherd utilized the entry qualification for trade union rights as an employment relationship, but such a relationship itself must be governed by the purposive words of Article 11.1 for the protection of his interests. Surely the European Court used the phrase employment relationship as shorthand for identifying those whom the exercise of such trade union rights was intended to protect. So if that's the approach in our Article 11, it's only fortified by reference to domestic law. And the obvious reference point is the case of Uber and Aslam, which Anne mentioned, which the judgment of which occurred after argument in our case in the Court of Appeal, but before judgment, and in respect of which we asked for the parties to be given permission to make additional written submissions. But Uber and Aslam, of course, was known to the Supreme Court. If we could have slide 10, please, Hitesh. This is a citation from the judgment of Lord Legate in Uber, and it's a very important one. He was talking about the auto cleanse case, which we haven't got time to go into, but he says critical to the understanding of that is that the rights asserted by the claimants were not contractual rights, but were created by legislation. Thus, the task for the tribunals and the courts was not, unless the legislation required it, to identify whether under the terms of their contracts, auto cleanse had agreed that the claimant should be paid the NMW or receive annual leave. It was to determine whether the claimants fell within the definition of worker in the relevant statutory provisions so as to qualify for these rights irrespective of what had been contractually agreed. In short, the primary question is one of statutory interpretation, not contractual interpretation. And we urged on the Supreme Court that that should be the approach equally to our Article 11. These were workers who were not seeking to enforce their contract. On the contrary, they were seeking to enforce what they claimed was a statutory right through their union to recognition under Schedule A1. And Lord Legate went on to say that the modern approach to statutory interpretation is to have regard to the purpose of a particular provision and to interpret the language of this provision so far as is possible in the way which best gives effect to that purpose. And he identified the relevant employment legislation as conferring benefits on workers. And if we could have the last slide 11, please. He said this, once the protective purpose of the legislation is recognized, it can be immediately seen that it would be inconsistent with the purpose of the legislation to treat the terms of a written contract as the starting point in determining whether the individual falls within the definition of a worker. To do so would reinstate the mischief which the legislation was enacted to prevent. It's the very fact that an employer is often in a position to dictate such contract terms and that the individual performing the work has little or no ability to influence those terms that gives rise to the need for statutory protection in the first place. The efficacy of such protection would be seriously undermined if the putative employer could, by the way in which the relationship is characterized in the written contract, determine even prima facie whether or not the other party is to be classified as a worker. Could you think of a more apt paragraph to define the situation of the Deliveroo riders in this case? But the Supreme Court, having cited Uber, completely ignored its purposive approach on the ostensible ground that our argument was in essence that unequal bargaining power was by itself a sufficient warrant for a purposive justification. The Supreme Court simply disregarded the purposive approach. They were illogical and simply wrong. That was never our simple argument. Our argument was exactly as Lord Legate had put it. Here is a protective piece of legislation. These workers can't influence the term. Here's an employer who has dictated a term which has the effect and probably had the purpose of excluding them from being workers in order to enjoy that statutory protection. And the Supreme Court at paragraph 63 say, well, many people have unequal bargaining power, but they can't demand a right to collective bargaining. I mean, what an absurd and irrelevant proposition. Lady Rose, who was one of the authors of the judgment, as it opens by saying, subsequently gave a lecture on worker status and considered the Deliveroo judgment. And in it, she cites these very passages from Uber without drawing the conclusion that she and the Supreme Court were wrong not to apply it in Deliveroo. And I wanted now, finally, just to compare the approach that effectively the Supreme Court upheld, the approach of the CAC. Could we have slide 13? No, we'll leave that. That's from the lecture. We haven't got time for that. But here is the CAC at paragraph 99. They said, even if Deliveroo did it, that is to say, inserted the substitution clause, even if they did it in order to defeat this claim and in order to prevent the riders from being classified as workers, then that too was permissible. All that mattered was the terms of the agreement analysed in holistic and realistic way set out in Auto Cleanse. Counsel for Deliveroo, of course, made no concession that either proposition was accurate. Deliveroo's purpose in deciding the terms of the agreement, and there was no question that the riders had any direct say in the matter, was immaterial. All that mattered was what the terms actually were. How can that proposition possibly stand against the judgment of the Supreme Court in Uber? How can it possibly be determinative of protective rights under Article 11 of the Convention? The fact of the matter is that the Supreme Court have successfully defeated both the purpose of Schedule A1 and the Human Rights Act 1998 in bringing home the rights under Article 11 for workers in this country. I can tell you that the IWGB is now considering its possession. I'm not going to tell you what they're going to do about it. Thank you for listening.
Thank you, John.
Leave it there for the moment. Okay, just for the moment. Good evening, everybody. Like John, I'm suggesting it wasn't genuine, but I'm genuinely honoured to be invited by Nicola Contouris to talk to you this evening, principally about the Irish equivalent of the Deliveroo case. But before I get going, I do have so you can go. I do have a presentation. I'll go through it very quickly, but I think it's worth making the point that whereas in Ireland, Uber are not allowed to operate, they haven't the necessary license or permission from the Department of Transport. I've noticed recently there are a number of proper taxi drivers have the Uber sign, but apparently they're just using the app. There are 4 or 5 different apps, free now, things like this. But Uber don't operate in the way they operate in any other jurisdiction where they do operate it. So they can only do it through licensed taxis. Deliveroo, however, do have very substantial presence in Ireland. Estimates in terms of the numbers, maybe 2,500 to 3,000 riders, or roos, as I think they certainly used to be called that. I remember attending or speaking at a conference in Dublin Castle a couple of years before COVID, and the newly appointed regional manager of Deliveroo, which covered Ireland and Northern England, was giving a presentation. And the two things I very much remember about their presentation. One was that the pitch was this suited students, ideal for students. You don't have a lecture at 9 o'clock, it finishes at 10, don't have another lecture until 2. You know, they can go off and ride their bike and made a bit of money. And towards the end of his presentation, made this big deal about this new insurance scheme that they'd entered into with the Roos, which guaranteed someone who was injured during the course of, you know, delivering whatever, a certain percentage of the income that they received over the previous 6 weeks. So I was sitting next to Paddy Kavanagh, who's the General Secretary of the Technical Engineering and Electrical Union. It's now called Connect. And anyway, Paddy's hand shots up, and whoever was moderating the session asked him to give his question. And he said, well, that's very interesting, but what I want to know is, what happens if one of my members crosses the road and is knocked over by one of your Roos, and my member's out of work for the next 12 months? Who's going to pay? Absolute silence from the guy. Did not in any way, couldn't react to that. Now, in terms of Deliveroo, I don't use Deliveroo. Nobody in the house is allowed to use it, or at least not to my knowledge, but or consent for having to pick up the bill at the end of it. But in 2022, the Irish arm of Deliveroo registered pre-tax profits of 1.95 million euro. Shortly after that, there was an interview in one of the Irish national papers, the Irish Examiner, with a young chap whose pseudonym was Leonardo. Now, Leonardo is one of, again, the numbers vary, but the estimate is around 80% of Roos or riders in Ireland are Brazilian. And the students coming in to study English language schools, and they come in under the terms of special student visa, which allows them to work for up to 20 hours a week outside of term time. Sorry, in term time, and then it's, I think, unrestricted outside of term time. But it's got to be proper employment, all right? Not self-employment, all right? Now, Leonardo, this is an interview in September 2023, said he works 6 days a week, 11 hours a day for an average of 82 euro a day. And out of that, so that's what, a little over 400 euro a week. Out of that, he has to pay 150 euro to the guy from whom he is subcontracting the app, because as a student, he's not allowed to work in the self-employed capacity. You go onto the Deliveroo website, and first what comes up is not even Portuguese, it's Brazilian Portuguese, reflecting, as I said, the significant 75–80% of the riders. And of course, the big slogan is work that fits around your life. So we go to, so that was just by way of introduction. And now, in terms of determining employment status in Ireland, there are effectively 3 different routes. If it's an employment rights issue, so you're claiming you've been unfairly dismissed, working excessive hours contrary to the Working Time Act of '97, complaint in the first instance is made to a Workplace Relations Commission adjudication officer. So it's a level similar to your employment tribunals, but the big difference between an employment tribunal, as I understand it, in England and Wales, they're known as industrial tribunals still in Northern Ireland, is that the adjudicator, the decision maker, is a lawyer. They're known as judges. Of the WRC adjudication officers, about, checked the figures the other day, there's about 60 of them. There'd only be a handful that have any legal qualifications. And a few years back, there was a challenge to the constitutionality of the legislation which establishes the Workplace Relation Commission. And one of the arguments was that, you know, hardly any of these people are lawyers. And our Supreme Court, in the judgment, again, it was a 7-judge Supreme Court. Normally, our Supreme Court sits with 5 really important cases. You get 7. So you had a 4-3 split supporting the constitutionality. But the Chief Justice made it quite clear that, as far as he was concerned, the other members of the court, in order to resolve an employment rights case, whether it be domestic legislation like the Unfair Dismissals Act, or whether it be legislation required by membership of the EU, such as, say, the Organisation of Working Time Act. Notwithstanding the possible complexity, particularly of the EU stuff, where you're looking at Court of Justice decisions, it wasn't necessary that you were a lawyer. You go on appeal to the Labour Court. Even though it's called the Labour Court, again, it's not a proper court. It's not part of the administration of, sorry, it is part of the administration of justice, but it's not a court. And again, you don't have to be a lawyer to sit on the Labour Court. And then from the Labour Court, you go to the High Court. For social insurance issues, the first instance is a deciding officer of the Department of Social Protection. That's an entirely paper-based exercise in terms of determining whether you're employed under a contract of service or a contract for services, because that determines your insurability status. You appeal to the Social Welfare Appeals Office. Again, these are all civil servants in the Department of Social Protection. They're nominally independent, and again, then up to the High, and then for tax purposes, and the Domino's pizza case that Nicola wants me to talk about, and I will come to it in a minute, Nicola. You start off with a revenue inspector, you then go to the Tax Appeals Commission, now that is a lawyer, and then again into the High Court. Now, back in 2016, Mrs. Justice Deirdre Murphy was giving judgment in a case called the National Museum of Ireland against the Minister for Social Protection. And what had happened here was that a lady was engaged, to use a neutral expression, by the National Museum of Ireland. She was specialized in conserving old pictures and things like that. She brought proceedings before the Workplace Relations Commission, or the Workplace Relations Commission's predecessor, alleging that she was a fixed-term employee and therefore entitled to the benefits of the Fixed-Term Work Act of 2003. Now, the decision maker decided that she was not an employee. She was not employed under a contract of service. She appeals to the Labour Court. Before the Labour Court issued its decision, the appeal is withdrawn, and she makes a claim under the social protection legislation, and a deciding officer ruled that, contrary to what the WRC had ruled, that she was an employee. This went on appeal to the Social Welfare Appeals Office, who uphold that decision, and then the National Museum take it into the High Court on the basis that they've made a number of arguments, including the res judicata argument that the status issue had been determined in the employment rights case. Now, the judge, in her decision, said, in her view, far more efficient to have one body charged with the resolution of all issues relating to employment status, but the legislature, in its wisdom, had decided to have different statutory schemes to deal with different issues. So again, you can see, you could have a scenario where, for employment rights purposes, you are an employee or you're not an employee, whereas for social insurance or tax purposes, you're in a different category. Now, another thing to note, there's no intermediate worker status in Ireland. You're either employed under a contract of service or a contract for services. We've dealt with the issue, when I say we, the Irish legislators, have dealt with the issue of agency workers by deeming them to be employed under a contract of service. So for virtually all purposes, regardless of what your actual legal status, you are deemed to be an employer of the agency for working time rights, maternity, adoptive leave, all of those rights. But in the context of an unfair dismissal case, you're deemed to be the employee of the hirer. So if you bring an unfair dismissal case, you don't sue the agency, you sue the hirer. Now, bizarrely, a number of pieces, and there's no obvious rationale behind this, a number of employment protection legislation define a contract of service as including a contract whereby an individual agrees with another person personally to execute any work or service for that person. They're deemed to be employed under a contract of service. So clearly, many of the individuals, and we'll leave aside the substitution issue for a moment, because that is dealt with by the Supreme Court in the Domino's case. You would have a number of people who would ordinarily be classified as self-employed brought within the scope of the legislation. But I said there's no rationale as to what pieces of legislation. So you have the employment equality legislation, outlaws discrimination on a range of grounds: gender, race, sexual orientation, age, things like that. Also then a very recent amendment to the Terms of Employment Information Act, which was amended by the necessity for Ireland to give effect to the Transparent and Predictable Working Conditions Directive. There's a new definition which includes people like that. Also, very interesting, the National Minimum Wage Act 2000. Now, what's really interesting is that no worker has, in what we might describe as the gig economy or engaged in platform work, notwithstanding that you have that definition in the Minimum Wage Act, nobody has brought a case. Why is that? I come back to my earlier point that the vast majority of Deliveroo riders are in effect working illegally. They're in the country as a student, they're perfectly entitled to be there, perfectly entitled to work. Many of them, I mean, my local pizzeria, apparently Italian pizzeria, but has a Brazilian pizza chef, and he's only working part-time. Now that's legitimate employment because he is in the PAYE, PRSI system. Sorry, just on the final thing there, I'm going to come back in a moment to deal with this issue of bogus or false self-employment. Yeah. Now, why is this important? Obviously, employment rights, social insurance. In Ireland, again, I'm not sure what the position here in the UK is, but in Ireland, employees pay 4% the salary into social insurance fund. Employers, depending on what your salary is, pay between 8.6% and 10.85%. So clearly, there's a considerable saving to be made already by employing people outside of the PAYE, PRSI system. Taxation. Well, again, as we all know, it's much easier to reduce your taxable income if you're self-employed. As a university lecturer, I get credit for books, law books, I think €300 a year. I'm not sure I could buy a law book for €300, but obviously as a barrister, I can write the whole thing off against tax. And then collective bargaining. I put this in because I knew that John would be talking about it. In Ireland, there is no right to engage in collective bargaining. There is a piece of legislation which the unions see as ineffective, and it was very effective until the pilots decided to take on Ryanair. But this is a process whereby if the employer does not engage in collective bargaining, the union can make an application to the Labour Court for the Labour Court to determine what the terms and conditions would have been had collective bargaining been engaged. So you're guaranteed an outcome. You're not guaranteed a process. The employer is perfectly entitled to say, no, I'm not bargaining with you. But the consequence of that, the downside for the employer, is that you run the risk of the Labour Court coming in and invariably in those cases which did go to the Labour Court, you'd have a look at what collective bargaining would have achieved in a comparable sector of the economy. So there's a famous case involving Ashford Castle. It's one of our 5.5 star luxury hotels, non-union. Well, in the sense that there were union members, but the employees didn't engage in collective bargaining. And the Labour Court made a determination increasing terms and conditions of employment by reference to what workers in the Gresham Hotel on O'Connell Street in Dublin, which is a union hotel, got on the basis, well, of collective bargaining. But the point about collective bargaining is, as you'll all be aware, that employees covered by collective bargaining, if you like, are exempt from the competition rules. Whereas if you're an undertaking, if you're a self-employed person, you can't engage in restrictive practices. So what we have in 2017, this is an amendment to our Competition Act, and we have a statutory definition of a false self-employed worker. Now, why is it necessary to have a definition of a false self-employed worker? Well, that's to get over the difficulty in terms of collective bargaining for workers who are self-employed. And this all started back in 2003 when our Competition Authority ruled that an agreement between Irish Actors Equity and the Institute of Advertising Practitioners in Ireland in respect of the terms under which advertising agencies would hire radio and TV voiceover actors, Competition Authority, that's in breach of Section 4 of the Competition Act, in that it restricts and distorts competition. And the union was threatened with fines of up to €4 million if it sought to implement the agreement. So coming out of that, we had a commitment by the then government that they would introduce legislation to enable vulnerable, self-employed, dependent workers like voiceover actors, session musicians, freelance journalists, I think were the three main categories. But like some of the other European countries, Ireland needed a bailout back in the bad old days, and the European Commission, European Central Bank, and the International Monetary Fund vetoed the proposal for legislation. Now, when we pulled ourselves out of the financial difficulties, this legislation was enacted. But interestingly, part of the dialogue was taking place between the Irish Congress of Trade Unions and the European Commission, resulted in a letter from some senior person in the relevant DG in the Commission to the General Secretary of the Irish Congress of Trade Unions, expressing the view that exempting vulnerable self-employed workers who were de facto employees from competition law, in their view, was not an effective means of protection, and suggested that the issue would be better addressed by if the legislature extended certain, not all, but certain employment rights to vulnerable self-employed workers. Now, just before I go on, anybody see what the difficulty with this definition is? All right, difficulty lies in number one, right? Performed for a person under a contract, the same activity or service as an employee of that other person. So what if the employer doesn't have any employees, like Deliveroo? I mean, I'm sure Deliveroo do have employees, but they don't employ anybody under a contract of service to deliver whatever Deliveroo delivers. So there is no comparable other, if you like, legitimate employer with whom you can compare yourself. Now, all the others I think are fine. Now, sorry, if it goes to the next slide, it is. So there's been a number of opposition initiatives, either by the Irish Labour Party, not to be confused with the the British Labour Party, but it is a left wing, but certainly to the left of centre. A number of measures. Sinn Féin have introduced a number of bills as well, so you can see from the title what the purpose of this legislation is. Now, none of these get anywhere. They don't even get necessarily a second stage reading. The government position, however, well, first of all, the main position, this was a ministerial statement in February 2018. There are already robust arrangements in place for dealing with complaints of bogus self-employment, but she made a number of commitments. She was going to establish a dedicated inspection team in the Department of Social Protection. Now, I understand that this is now, it's either 13 or 50, I can't remember, but it's not a great number of inspectors, to provide for deciding officers to make group or class determinations. So instead of just ruling on one, for instance, one rider as to what his or her employment status is, they would be empowered to make a kind of a class ruling on all workers of that particular category. There is a code of practice which had been drafted by Congress, the Employers Association, Revenue, Social Protection, but it's not a statutory code of practice. And then finally, she would introduce anti-victimization measures in respect of workers who sought from somewhere, probably a deciding officer, a determination of their employment status. Now, apart from the fact that a dedicated inspection team has been set up, none of the other commitments have been delivered on since 2018, which is relevant when we come to the final slide. So I'm going to very quickly just run through a couple of cases. So the 1998 decision of the Irish Supreme Court in a case called Henry Denny and Sons Ireland Limited against the Minister for Social Welfare. This was an appeal by Henry Denny, a well-established company that make sausages and ham and whatever, originally from Kerry. And they were disputing a social insurance ruling that supermarket demonstrators, like the lady in question, I couldn't find a Henry Denny one, but anyway, supermarket demonstrators were employed under contracts of service, contracts of employment. And that, for many, many years, had been the leading employment status case, even though it's not an employment case, it's a social insurance case. So next one. And vegetarians might want to turn their eyes away in respect to the next case, which is the Minister for Agriculture and, Barry against the Minister for Agriculture and Food from 2009. As you probably be aware, Ireland has a very extensive meat industry. We had a visit last week from the Chinese Prime Minister, the big outcome of which was that Irish beef is now going to be, again, exported to China. It's worth millions to the Irish economy. But anyway, because of the large number of exporting countries, very rigorous, as you can imagine, very rigorous checks maintained by the department in respect of meat. So the department would employ a number of full-time veterinary inspectors, proper civil servants, but then there's a huge number of TVIs, temporary veterinary inspectors, who are effectively on panels, and they come in perhaps on a regular basis, in your classic gig economy worker, in that the department were under no obligation to offer them work, although there was an expectation the higher up the panel you were, that depended on seniority, more likely you were going to get called in. Anyway, the department decided to close down one of its meat places in, I think it was in Mitchelstown in County Cork, and there were 5 temporary veterinary inspectors, Mr. Barry being the lead one, who contended that they were entitled to a statutory redundancy payment and compensation under the Minimum Notice Act because they alleged they hadn't been given adequate notice. So at first instance, the ruling was that they were employees. Now, it's really important at this particular point to appreciate that, as in the United Kingdom, if you want a redundancy payment or things like that, a certain period of continuous service is required. So it's not enough just to say, I'm an employee. You have to show that you've been continuously employed under the Minimum Notice Act for 13 weeks before you get any notice rights. And in the case of redundancy, it's minimum 2-year period. So in ruling that there are employees, the tribunal in effect ruled that they were engaged in continuous employment, even during the periods when they weren't being called in to inspect the meat. Now, we're not talking huge statutory redundancy. First of all, it's capped at €600 a week. So, and then, that's multiplied by the number of years of service. So we're not talking, millions or even thousands here. The department appealed to the High Court, and the High Court, very influenced, obviously, by the arguments of distinguished counsel, the Minister for Agriculture at the time, was represented by Anthony Collins, who's now one of the Advocate Generals in the Court of Justice, very experienced, very eminent silk, and he convinced the High Court that the tribunal, in assessing their employment status, had misunderstood certain UK decisions, particularly the what's the power one, John? The power company one. Carmichael. And
Well done.
all right, the tour guides around Sellafield, or whatever. And the High Court sent the matter back to the tribunal to reconsider in light of its ruling. Now, the tribunal took the view that the High Court was in effect directing them to find that the temporary veterinary inspectors were self-employed. So they unanimously came to that decision. They then appealed to the High Court, thrown out, they go to the Supreme Court, and the Supreme Court said, no, Judge Edwards didn't, in the High Court, didn't require you to find that they were employees or self-employed. That's up to you, up to the tribunal to decide. So eventually, the matter went back to the tribunal finds, I think by a majority of 2-1, that they were self-employed. There was a further appeal to the High Court. And again, you can't imagine the legal costs involved in this. And the guys, by the way, are represented by their trade union, Veterinary Ireland. Eventually, the case is settled. But as I said, this is where this concept of mutuality of obligation infects Irish law. And then we get the Domino's case from decided in October 2023. And John made the point about the Deliveroo case starting. When did you say, John? 2016?
Yeah.
This case started in 2010, in the sense that the tax inspector decided that Carshan Midlands Limited, so Domino's franchise, they were assessed in respect of the tax years 2010, 2011, in respect of their workers, a little over €200,000. It was like €215,718. That was the tax assessment. And the tax assessment was based on the belief of the inspector that the delivery drivers were employees, not self-employed. Goes on appeal to the Tax Appeals Commission. Tax Appeal Commissioner rules these guys are employees. Goes to the High Court by way of an appeal by way of case stated, which involved the tax commissioner asking, a bunch of questions. So, was I right to do this? That kind of thing. Mr. Justice O'Connor in the High Court upholds the Tax Appeal Commissioner's decision. I think this was in 2019. Goes on appeal to the Court of Appeal. Court of Appeal split 2-1 in overturning the Tax Appeal Commissioner's decision, and then Revenue decide to go to the Supreme Court. Now, it's the judgment of the Supreme Court, and apart from people on the panel, and I'm not sure if everybody on the panel's read it, but it's somewhat long. It's 191 pages long. But the final few pages very conveniently list out the contract in full between the drivers and Carshan. So it starts off by saying, where is it? Yeah. Whereas the company wishes to subcontract the delivery of pizzas, the promotion of its brand logo, and the contractor is willing to provide these services to the company on the terms hereinafter appearing. 1. The contractor shall be retained by the company as an independent contractor within the meaning of and for the purposes of the said expression. And then there's a lot of stuff about cars. Paragraph 9, the company points out that in keeping with all self-employed individuals, the financial risks and or rewards associated with providing the services as outlined in this contract are strictly under the control of the contractor, and the company bears no responsibility whatsoever for same. And in particular, the company does not warrant a minimum number of deliveries. Paragraph 11, I'm just mentioning these because these are the key ones in terms of the Supreme Court's analysis. The company accepts the contractor's right to engage in a similar contract delivery type service for other companies at the same time as this contract is in force. However, this right does not extend to delivering similar type products into the same market area from a rival company at the same time. And then in terms of the substitution clause, clause 12, the company accepts the contractor's right to engage a substitute delivery person should the contractor be unavailable at short notice. Such person must be capable of performing the contractor's contractual obligations in all respects. And a lot of those contractual obligations relate to the car and insurance and roadworthiness and things like that. And then it ends with the usual standard thing. I am aware that any delivery work undertaken for Karshan is strictly as an independent contractor. As such, Karshan has no responsibility or liability whatsoever for deducting and or paying PRSI, as pay-related social insurance, or tax on any monies I may receive under this agreement. Now, the hearing before the tax appeal commissions, an in-person oral hearing, evidence was given by 5, I think, or 6 drivers, which was important in terms of the arrangements that they entered into in terms of signing up to the roster and what they did when they were hanging around. But if I can just sort of quote you from page 168. So in terms of the substitution clause, the Supreme Court cite the finding of the Tax Appeal Commission. So paragraph 256, they say the commissioner carefully examined the substitution clause. She concluded that this did not involve an unqualified power to delegate the work contracted for. She described it as follows. He did not have the option to subcontract, i.e. to engage another person to perform the services in circumstances where he would continue being paid for the services. He could arrange for another of the appellant's drivers to work his shift in the event that he was unable to. The substituted driver would be paid as opposed to the driver originally rostered. This arrangement is akin to the swapping of shifts between drivers. And then the Supreme Court go on and they cite the very passage in the Pimlico case that John mentioned about a limited right of subcontracting. But I think the key thing here is that the substitution, the substitute had to be another one of the appellant's drivers and satisfied all the other conditions. And the company paid the substituted driver. It wasn't as if they paid me and then I, hand over a percentage of that to the guy I've got in to do it. Well, what's my next slide? Yeah. So this was the argument that Karshan, Domino's put forward. And there were a number of limbs to their mutuality of obligation theory. So the mutual commitments in question have to present some type of ongoing continuity. They had to have a forward-looking element extending into the future. There had to be an obligation on the part of the employer to provide work, and there had to be an obligation on the part of the worker to perform it. So they're talking about future stability. And again, it's kind of hard, kind of sitting there listening to, very experienced senior counsel, making this argument, and I'm thinking, right, so, fixed term contracts, where's the future stability there? I can be employed on a fixed term contract for a month, right? No. And then when I'm offered it, I'm under no obligation. First of all, when I go for a job, the employer is under no obligation to offer it to me. And obviously, the employer's not supposed to discriminate against me on grounds of age or whatever. But I have no right to be offered the job. And if I am offered it, I'm under no obligation to accept it. But if I am offered it and I do accept it, there's a contract. And it's clearly a contract of employment, unless, I fall into, I'm a taxi driver or something like that. So the Supreme Court, the next one, said that in any given case, whether a worker is an employee should be resolved by reference to the following questions. And the first 3 are very straightforward. Does the contract involve the exchange of wage or other remuneration for work? Clearly, in the Domino's case, it did. Is the contract one pursuant to which the worker is agreeing to provide their own services and not those of a third party? Again, that's what the substitution clause came in and was, as I said, dismissed by both by the Tax Appeal Commissioner, the High Court, and then Supreme Court ultimately. If so, does the employer, it should exercise sufficient control over the worker to render the contract one that is capable of being a contract of service? And again, ample evidence of control. They did not take calls from customers. They did not employ their own labor to undertake the cast. They took no economic risk. They worked exclusively from Karshan's premises. The ability to maximize their profits was limited. They didn't advertise their services. They were required to wear uniforms. They had to have the Domino's Pizza branding on their cars. In short, their economic activities were so restricted by the terms and conditions imposed by Karshan that they could not be said to have been engaged in their own business. Their work was in every sense work for Karshan and was directed towards advancing its business and not their own. Now, the company made great play, or counsel the company made great play on the fact that the company had, the drivers were required to provide their own vehicle. And I came across an old, well, it's not that old, well, specifically, it's a book from 1934. It's by a late barrister called Bernard Shillman, and it was all about workmen's compensation law in the Irish Free State. And there were a number of cases involving carters. So these guys had their own horse and cart, and they would either deliver milk from the farmer to the creamery, or vice versa, or they'd be carrying stones from a quarry. Now, classic gig economy work. And I made the point that, I have no idea what a horse and cart would have cost in, 1910, but it's probably around the same as what you pay for, a cheap runaround, a Seat or Skoda or something like that. But what was really helpful was the New Zealand Uber decision from 2022. And again, New Zealand, like Ireland, is a binary system. There's no intermediate worker category as you have here. And Chief Judge Inglis in the New Zealand Uber case adopted the position that the fact that the drivers provided their own vehicle and smartphones was neutral. So it's not the sort of investment that would indicate that they were carrying on their own business. And again, that's cited and followed by the Supreme Court. And then if the above questions are answered in the affirmative, the decision maker must then determine whether the terms of the contract, interpreted in light of the admissible factual matrix and having regard to the working arrangements between the parties as disclosed. So again, you have a situation where there's perhaps a tension between the way the contract is performed and what the contract actually says. And I'm being told to hurry it up. So this is the final thing. You'll all be aware that the, well, maybe not, and there's of limited interest since you're no longer in the European Union. But after many months of negotiation between the European Parliament and the European Commission, an agreement was reached on a draft platform work directive. And when it goes to the Council of Ministers, and it's withdrawn on the basis that there's a considerable number of member states, led by France apparently, but including Ireland, who are going to vote against it. And this is the department's statement as to why it took the view that it wasn't going to back the platform work directive. And I'm just going to end here by just looking at a recent newspaper article from the Irish Times, where Deliveroo have been lobbying government ministers in the context of Ireland's support or not for the platform work directive. And representatives Deliveroo and digital platform companies Barmes, Gigable, and Bolt argued that in its current form, the EU proposals, including the rebuttable presumption of employment, puts at risk genuine self-employment. I find it hard to read that without a grin or a grimace. Anyway, sorry, Nicola. I'm sure, I mean, I might, if there are any questions, I think it's just thank you at the end, isn't it? Yeah, thank you. And there's my email address if anybody needs to, wants to contact me about this. Listen, sorry, Nicola. We're very fond of talking. Anyway, thank you for listening.
Thank you. And so Lizzie.
Well, we're after our time. So because the session was supposed to end 5 minutes ago, so I just need a bit of guidance. We were going to each speak for 15 minutes, so I've got things
look,
to
I'm
say.
real
but,
sorry. I've come all this way.
Oh,
So-
it's absolutely fine. I've got things to say, but I'm perfectly happy to not say them. And is there any time for any questions? I need guidance from the.
I think you should speak anything.
I'd like you can wrap up.
I've spent
Can wrap up,
I've been listening and I'm very fascinated with what everyone's been saying, while also trying to think, how can I cut mine down, what I'm saying, to the minimum amount? So I'm going to go for 3 minutes and then who knows, I'm sure a lot of people have to go home, but if there are any questions. So really, what I was wanting to do was, in a sense, stand back a bit from some of the detail and look a little bit backwards in order to think about where we've reached with this delivery decision and what might that tell us at this moment with this decision about where we go from here. My standing back is a little bit because, having spent decades obsessing about labour law and obsessing about all these cases and obsessing about contract law, I spent the last few years not doing so much of that except in my teaching. I've been thinking more about equality law, so I feel like I've got a bit of a vantage point that I haven't had ever before, really, of standing back. So I've kind of been coming back to this to talk about this. And the other thing is I take a very sociological approach to thinking about cases, who judges are, litigation standards, which does ask you to stand back a bit from some of the detail. So that's, I guess, the lens that I'm bringing to you with this. And what I want to say, just maybe 4 points. First of all, the Uber decision, there's a phrase that people say about the greatest teachers are teachers who make the ordinary strange. And for me, that Uber decision made the ordinary, for labour lawyers, strange, in the sense that it showed us what I think a lot of us subjectively felt, but they showed us that for decades, as lawyers, litigators, academics, we just got in such a tangle of legal, doctrinal, technicality and complexity, and backwards and forwards between highly paid lawyers advising their clients, essentially about how to avoid a set of legal obligations and to make choices about who they would accept them towards. And often the people that they would not accept legal obligations towards were the ones who, in terms of bargaining power, needed them the most. So this ending up with this obsessive focus on the technicality that ultimately ended up just saying, yes, it's okay. You can find ways with good lawyers to avoid all these obligations. And, you know, sometimes other brilliant lawyers might make a little dent in that. That would often be short-lived and we'd be back to the same. We just carry on this technical kind of dance with this net effect. And the Supreme Court came along and just said two things which are just so blindingly obvious in hindsight. But no one had, at least in that position of power, had been saying them. One of which is, even though these are common law concepts, they're in a statute. and a statute with a protective function. And you can't let the fact that they're common law concepts that are about agreement making, you can't let that blind you to the fact that these are protective measures, and we cannot let the very inequality that they're designed to do something about ensure that these statutory protections are avoided. It's a stunningly beautiful and very, very simple point. But the second thing they said is, even if that's not enough, there are anti-avoidance provisions in these statutes. I'm going over my 3 minutes. There are anti-avoidance provisions, and these, just like there are tax avoidance provisions. And by the way, what's been going on has been avoiding these obligations. So this amazing moment, I have to say, the Domino's case, which I did read the 191 pages, and it's another beautiful judgment. It certainly gets down and dirty with the doctrine, but it also just unpacks a lot of nonsense that has been said about mutuality of obligation that a lot of us have been worrying about and writing about for a very long time. So this does happen. There are these moments that happen in adjudication. The labour lawyers, they don't happen very often. There's a long history to why we worry about giving power to judges and relying too much on judges to achieve equality and fairness for working people. Okay, but the question for me that I'm left in is, then we get to Deliveroo, and is there anything in that simplicity of Uber really that can help us in recovering from the Deliveroo judgment? That's my question. And I would have a few things to say about it, but I'm not. But I will try to just run through them really quickly. One, purposiveness. I really worry about the translation of a purposive approach up a level to the international sphere. I think it gets very, very complicated, and particularly in relation to anything to do with collective bargaining, because there is such a deep tradition of voluntarism in all of the measures that I, over the years, have been thinking about. So I worry about where a purposive argument is going to get you at an international level. I have more hope for an anti-avoidance argument. But I think what it probably translates into is a bit what Anne was saying. It's about discriminatory provision of human rights, effectively. Is there a route in there? The next thing that I want to say is, what role are judicial politics playing? Uber was 2021, we're now in 2024. What is going on with the Supreme Court and the European Court of Human Rights? And is what's going on with them in terms of judicial politics in the context of their decision, is it making it, meaning they're in a time of peril, that we are all in a time of peril, where they are going to back off from tough decisions about labour rights and particularly labour human rights. So then my very last thing is, there's a powerful case for a really clear-eyed assessment of what we've got out of Deliveroo and what we've lost. I'm sure the IWGB, with John's counsel and others, are really thinking hard about that. I don't think we should despair. I've been reading Manoj Diaz-Abe's work about the other functions that strategic litigation plays. There's a lot of work in this area in terms of movement building, creation of political consciousness. There's such important things that are going on around this litigation, but I think there's big questions about where we're going to get with Article 11 and where we're going to get with judges at the moment. And finally, a legal strategy, a litigation strategy, I think almost above anything else, needs a political strategy with a small p and a large p. And this is the moment to be trying to persuade potential new governments that may appear to be doing something in this area, and something that actually works and is not at the mercy of cases. Okay.
Well, thank you all very much. You've preempted my request to say thank you to a very distinguished panel. So thank you all so much. Sorry, we overran slightly, and hope you all have a good evening.